attorney or a POA is a legal document in which a grantor, known as the principal, bestows unique powers on another person, known as the agent or attorney, to act in a certain manner as specified in the POA. The Power of Attorney Act, Indian Contract Act, Registration Act, and Indian Stamp Act are the numerous statutes that govern power of attorney in India, including the corresponding state level acts. However, the question arises as to whether we can rescind these rights once they have been conferred, or can a power of attorney be revoked, reverting all powers granted to an agent to the principal? The answers are yes to both of these queries. The principal can revoke a power of attorney at any time. However, when preparing the format of cancellation of power of attorney in India, a clause should clearly specify that the power of attorney is not irrevocable at the principal's will. If the format of cancellation of power of attorney does not include such a clause, the principal has the ability to cancel it at any moment, and the agent can no longer, on behalf of the principal, after the power of attorney has been revoked. Irrevocable power of attorney can be created if the document has an irrevocability provision which states that the principal has no capacity to revoke the power of attorney, or that the principal waives the right to withdraw the power of attorney. However, because they are confined to certain objectives, irreversible powers of attorney are rarely used. Though neither the Indian Contract Act nor the Power of Attorney Act specifically addresses the cancellation of a power of attorney, the courts have interpreted the general rules for applying the scenarios to revoke the power of attorney from time to time. As a result, the power of attorney can be revoked by 1. The Principal's Act. The principal agent relationship can be ended by the principal at any time for a variety of reasons. When the agency's business is completed, for the purpose for which the instrument of POA was created is fulfilled, when the principal cancels the POA with his authority, and when either the principal or an agent both becomes insolvent of unsound mind or incapacitated to carry on the POA. These are just few examples. And the second is when the agent is interested in working for the agency. Now, Section 202 of Indian Contract Act states that if an agent has a personal interest in the agency's subject matter, the agency cannot be terminated without an express contract or the agent's consent. And third, an agent's breach of contract. The POA is initially irrevocable, however, it can be removed in the event of extreme mismanagement on the part of an agent. When an agent fails to comply with the terms of the contract or acts beyond the scope of the contract's powers, the principal can revoke the powers assigned to him at any moment by cancelling the power of attorney. Now, it is important to mention that while making the format of cancellation of power of attorney in India, there are two cases that follow different process. In the case of irrevocable power of attorney, which is difficult to revoke, particularly when an agent or attorney has an interest in the subject matter, the same can be cancelled in the event of an attorney's breach of powers. If this occurs, a notice of revocation can be filed against him, and in rare situations, a court of sufficient jurisdiction may be contacted to seek such revocation. And in the case of a durable power of attorney, it will be automatically revoked in the event of the principal's death, insolvency, incompetence, or insanity, or both. Now we move on to the procedure of how the format of cancellation of power of attorney in India can be made by an NRI. First, to cancel the revocable power of attorney, that is notarized by a certified notary advocate, first send a letter of deed of revocation to the appropriate authority. The reason for the revocation is the effective date of the revocation, and the repercussions should also be stated in the letter of revocation. Second, to give the attorney or agent a sufficient opportunity in the revocation proceedings, a notification of this letter of revocation should be duly served on them. Thirdly, the notice of revocation should be published in a local or national media so that everyone who has dealt with the attorney or the public in general is aware that his or her powers have been removed and that he or she will no longer represent the principal. Fourth, The same authority who registered the power of attorney, that is, the registrar or sub registrar, shall register the letter of revocation or deed of revocation. And in conclusion, after the letter of revocation has been registered, a copy should be sent to the attorney and any other people with whom or she or he has been in contact, so that they are aware of the situation. Thank you.